first witness this morning for the third hearing on House Bill 248 will be Jim Moody. Mr. Moody, if you would make your way to the podium and give you a heads up that on deck is Tony Diabasi. Mr. Moody, welcome to committee. You may proceed.
Thank you, Chairman Lips. I'm going to try to abbreviate this as I got a little verbose in my written testimony. I'm here today to testify in support of Substitute Bill 248. Mr. Chairman, Vice Chairman Holmes, Ranking Member Russo, and members of the committee, I practice public interest law in Washington, primarily from a libertarian point of view, and I'm also a member of the Vaccine Injured Petitioners Bar and do a great deal of work on vaccine safety and science policy. Thank you for the opportunity to support the bill. I want to talk about three main topics. One is that this is a pro-business bill. Passage of this bill implements the traditional obligation of the legislature under the Ohio and federal constitutions to protect government's role and to protect the proper balance between the government and the private sector. Political choices should not be privatized. It is the job of the government, not the private sector, to enact uniform public health requirements, especially where there is a need for statewide uniformity in the case of a respiratory virus. As with rampant social media censorship now, there is a great concern that many political choices are being taken by the private sector, and if conducted by government, will be unquestionably unconstitutional. Today it's vaccines, but soon private businesses will be looking at gun ownership, family relations, nutrition, mental health, and every kind of lifestyle choice, and that's a direction we don't want to go into. Enforcement of vaccine mandates is unworkable and at the very least will lead to an underground economy in fake vaccine passports. Especially with COVID, vaccine status has little to do with preventing the actual spread of the disease. That's because, at least for the two mRNA vaccines, they're primarily treatments dealing with symptom and death reduction, and were never even licensed or approved for the prevention of infection. The complex relationships between the human immune system, the duration of antibodies, et cetera, are entirely unknown. Again, this is a very slippery slope, and we certainly don't want to watch private businesses get into the area of testing, antibody testing, booster shots, titer testing, and the like. And there's eventually private companies will be requiring bubble suits just to come in the door. As I said, this is pro-business legislation. Shifting the burden of government choices to the private sector asks businessmen to become doctors. They are not. Businesses have much more to do than concern themselves with pondering CDC guidance documents and the morass of pronouncements by distant, unaccountable government experts like Dr. Fauci. Is one mask enough or too many? Goggles today, a hazmat suit tomorrow. It's constantly changing. These are jobs for government and not asking businessmen to be armchair doctors. Also, a concern is that vaccine status is to some extent a proxy for race and low SES status. People of color are about half as likely as the general population to get the vaccine, at least so far. And you would suggest I refer you to RFK Jr.'s documentary on medical apartheid for good coverage as to why some hesitancy is appropriate given the rather disgraceful history of government experimentation on people of color. We certainly don't want to see a situation where without this legislation it'll be primarily the white and the wealthy allowed back to a life of near normalcy. Medical choice is a civil right and must be protected. The second point is that the COVID vaccines are emergency use authorizations. That is not FDA approval. There may never be FDA approval. The statute itself, the guidance documents, the fact sheet given to patients, et cetera, all make clear that this is entirely voluntary. There can be no mandates. The guidance given at the CDC's ACIP meeting from their experts was, again, there can be no mandates. The only court that's ever ruled on this in the anthrax case back in 2005 basically said we don't want our soldiers to be treated as guinea pigs, and that was what led to the whole EUA process. And I would make the same point here, that we do not, government or private sector, allow experimentation on anybody, especially children in the case of college kids and school kids. The clinical trials aren't yet done. They're supposed to go out to 2023. As I said, the COVID vaccines may never achieve final approval, and to put private business in the process of experimenting to have no jab, no job rules exposes them to liability under the workman's compensation policies, and this opens the door to more litigation, more uncertainty, and more risk for business, which creates an unfriendly business climate in Ohio. The last area I'd like to get into briefly is informed consent. The modern law on informed consent traces to the Nuremberg Code. Here it's implemented in what are called the Belmont Report, leading to the federal guidance on informed consent, which is embodied in 45 CFR Part 46. It says that as long as these vaccines are treated as experimental, there must be free and unburdened choice and voluntarism that would apply to both the public and the private sectors. Vaccines, even once they're finally approved, must still be regarded as experimental, because the FDA does not release for public consumption publicly the phase 4 control data to be able to understand what the safety is of these vaccines going forward. Informed consent has a rich history in case law. It's embodied in the revised code in Ohio. In addition to that, informed consent has gotten into the case law on bodily autonomy. That goes back to Roe versus Wade, the Griswold case, Planned Parenthood versus Casey, and the Cruzon case, as it was particularly applied to medical care, that the modern Supreme Court has recognized over and over and over again there's an area of bodily autonomy. It comes from privacy, it comes from substantive due process, it comes from the notion of respect and dignity that the government certainly may not cross. And because now, as I said initially, we're asking the private sector to perform government functions, it's appropriate for this committee to protect that civil right by preventing the private sector as well as the government sector from crossing that line into bodily autonomy. Lastly, I'd like to point out that part of the problem Ohio has is actually caused by the federal government. Vaccine companies and doctors are given absolute immunity from lawsuits, taking away the traditional protection of the tort law. It would be entirely appropriate for the legislature, for example, to consider banning products for which there is tort immunity, because it denies the citizens of Ohio the traditional protection of the law in case there are injuries, which there certainly are from vaccines, as with any drug product. In the case of the COVID vaccines, it's even worse, because they have absolute immunity under the compensation or the countermeasures injuries compensation program. Good luck finding what that is. It's a super secret program, began in 2009, and it's even worse than the rather lame vaccine court, because it's impossible to get data to do the causation analysis. The government keeps data on vaccine injury more secret than our nuclear codes, which is another reason why this legislature has to give strong protection to the citizens of Ohio against any kind of public or private vaccine mandate. I think that's probably about my 5 minutes, so I certainly thank you for the opportunity to present testimony and appreciate the opportunity to enforce vaccine liberty as a civil right, and I'm happy to answer any questions.
Mr. Moody, thank you very much for your presentation, and your written presentation as well is really interesting. Committee, questioning. We'll open the questioning with Ranking Member Russo.
Thank you, Chair. Thank you so much for being here and for your testimony. I would just like to point out, I mean, you noted many times during your testimony that this is a pro-business piece of legislation, although I would like to point out that this committee has received a letter from a number of organizations, including the Ohio Chamber of Commerce, the Ohio Business Roundtable, the Ohio Manufacturers Association, the Columbus Partnership, the Dayton Area Chamber of Commerce, as well as many other businesses and healthcare industry, that this is in fact not pro-business and they are opposed to this legislation. So just wanted to point that out. But my question for you is, can you comment on, in the last week, the federal Equal Employment Opportunity Commission has issued a statement and a memo regarding this issue of the ability of businesses to require vaccinations for their employees or to offer incentives. And they've pretty clearly said that, yes, this is allowed, of course, with some constraints around it. You have to have exemptions for medical and religious reasons. But could you comment on that? And, you know, that seems to go against what it is that you're saying in your testimony.
Sure, thank you. Through the chairman to Member Russo, thank you for your question. It's a good question. The EEO guidance, this goes back to really 2007 originally. It is very important to recognize that protects religious exemptions, which would include what you all call out here conscience objections. So it's really quite a broad exception. And it's a traditional exception given to many of the civil rights by the federal government. And so that would be consistent with the exemptions already allowed under Ohio law. The reason primarily that this is a pro-business bill is because in the day-to-day work of a business, to call on them to make very complex medical choices, in part for their customers and in part for their employees, calls upon them to have expertise they just don't have and puts undue stress and burdens and the like. And for a pizza parlor, you know, to say, well, we're going to have a vaccine mandate for our customers, for a vaccine for our employees, has almost no effect in general because in the case of COVID anyway, it's a respiratory virus. So what one business does, as much in good faith as that may be, and as stressful as those choices may be for employers and customers, it's not really going to affect the progress toward herd immunity. Combination of vaccine and infection is going to provide the necessary protection to Ohioans. So it puts undue stress on individual businesses and really no benefit at all to the state or to the particular business, and does expose them, at least in the case of employees, you know, the no jab, no job rule, to possible liability under workmen's compensation law. And you know, to have a patchwork of rules where some employers do it, some don't, some customers are required, some don't. Gosh, I even got a notice for the Grateful Dead concert I'm going to in Cleveland in a couple of months that to get into the pit, I've got to have a vaccine. You know, so just it makes lifestyle choices very, very difficult, and it puts an undue burden on businesses, and that will create generally an unfriendly business climate in Ohio of stress and tension that other states may choose to go in more of a uniform direction.
So follow up, please. Chair, through the chair, thank you. But just to emphasize, the state is not currently under a vaccine passport program, nor are they mandated to check someone's vaccine status. No business is required to do that, but some businesses are asking that, yes, they be able to put in place, either for their own employees, for example, if you were a hospital or a healthcare provider, or to be able to offer incentives to encourage your employees. So again, I will push back. You are calling this pro-business, yet the business community, you know, right here, whole list of them, are saying that this is in fact not pro-business. This is tying their hands. This is not what allows them to operate and get back to normal.
Right. Well, I think, and through the chairman to Representative Russo, thank you again. I think that's part of the problem, since there is no uniform vaccine passport. Each individual business having to struggle with this imposes additional business burdens. Will they need to check a app, an ID at the door? Will they have to get certified notes from doctors for their employees? A lot of things sound like good ideas in the beginning. Oh gosh, we're protecting, but it's the implementation where it falls down. Or it may just end up being ineffective. Customers will get fake IDs, fake vaccine passports, and employees will get fake notes from their doctor or whatever. It's the implementation of this, despite the very well-meaning intentions of the business organizations. It's the actual implementation that's going to create a great deal of stress and problems for individual businesses, especially in lack of, absent some sort of uniform state vaccine passport, which is itself a terrible idea.
Again, Mr. Chair, I will push back. No one is requiring businesses to do this. They are just asking to be able to make the decision if they so choose. So thank you. That's all.
Committee, additional questions? Representative Gross.
Chairman Lips, to Mr. Moody, thank you so much for being here. To the best of your knowledge, since you are in Washington, D.C., because I have thousands of emails to my box speaking otherwise. Have you noted that employers are actually terminating employees if they do not get the vaccine? And maybe not name those, but could you quantify them for me?
Through the chairman to Member Gross, thank you for your question. There's a lawsuit in New Mexico now against, I believe it involves a state prison guard. The EEOC has dealt with a lot of cases over the years, mostly out of the hospital setting for nurses, and in most cases they are able to successfully work out accommodations. But there are several employees who have been fired, in some cases for even bringing up the question. In some cases, they actually aren't even informed of the choices they do have under federal and their appropriate state law. And so there is a fair amount of litigation. I think in the short term, it's going to grow because there's going to be a lot of bullying. Under federal law, employers are required to provide reasonable accommodation. In many cases, and I think it'd be useful to hear, like from the Cleveland Clinic, for example, to see what they do in their accommodation program. But they have worked out through the professional associations like IDSA and other professional associations appropriate accommodations. It can be for the flu vaccine something as simple as mask wearing. Or, the industry is really quite good at working out accommodations according to the federal dictates. Yes, people are being fired. In the short run, there'll be more people being fired, particularly while these vaccines are under EUAs, because the whole idea of asking an employee to participate in a medical experiment is pretty grisly. Yes, there will be a lot of litigation, which is yet another reason to implement this protection as a civil right at this point, to clarify the law. I mean, Ohio took the lead in 1884, passing one of the first civil rights laws in the nation. Ohio has always been a strong leader in protecting civil rights against both public and private intrusion. So this is entirely consistent with the long history Ohio already has in protecting civil rights.
Committee, additional questions? Representative West.
Thank you, and I'm sorry I missed some of your testimony, but just for a point of clarity, you said number of people are being fired. Is that in Ohio or is that nationwide? Could you speak to Ohio specifically?
Through the chairman to Member West, thank you. I, off the top of my head, can't think of anybody I've heard about it in Ohio yet. I think that's a testament to Ohio being, frankly, reasonably forward-thinking in not being, an employers turning into bullies and practicing medicine. So I don't know of any in Ohio. I'm happy to do a thorough study and report back to you. But nationwide, there are stories popping up in the press all the time of people who are being fired.
Thank you, Mr. Chairman.
Committee, additional questions? Mr. Moody, thank you for making the trip in this morning and sharing your expertise with us. Since you work on a more national scale than just Ohio, can you give me an example of one or two other states that are ahead of us in this process? Because we're just now in the hearing process for an anti-discrimination or freedom bill or whatever you want to call this bill. Can you tell me of one or two other states that are ahead of us?
Thank you, Mr. Chairman. Well, I would call this both anti-discrimination and a civil rights bill. I mean, there's a whole bucket of things: race, color, creed, sex, national origin, et cetera, that we put in that bucket of civil rights. That 100 years ago, we gave up the idea that was intrusive into business. It's a balancing test. Yes, we regulate business all the time, but we do so to protect the greater social good of liberty and non-discrimination. Florida is famous in the news for taking the lead and banning vaccine passports. I think Arkansas has a similar bill. In all honesty, I think Ohio has really stepped up to the plate in showing national leadership here in creating both an environment that's protective of liberty, but also is pro-business. In Florida, you'll see the whole tension now with the cruise line industry. They don't want vaccine passports because they want to open the cruise line industry and get that segment of the business and all the thousands of jobs that creates back on board. So that's actually kind of a good illustration of why mandates, in that case, publicly enforced through CDC or privately enforced through the cruise industry choices, are really a very, very bad idea.
There have been some suggestions by the business community and opponents to the bill that it goes too far, that this bill's too broad. So I just would like your opinion, and that's really what I'm asking for because of your expertise, is just your opinion. Does this bill go too far? Should this bill be amended down to a smaller or more streamlined version? I mean, we're hearing that a lot, and the business community has talked to us about that. So what's your opinion of that?
Thank you, Mr. Chairman. And that's also a very good question. Actually, when it comes to the civil right of medical liberty, it should be actually broadened to include other medical choices. And it really is not a business person's or a government's job to know about the medical, what you put in your body, what conditions you have, et cetera, et cetera, et cetera. And so some civil rights were the obvious ones based on the color of your skin. Sometimes the less obvious ones, which God you pray to. In this case, when we're dealing with medical issues, we're dealing with the most private and intimate choices about you and your body, and that deserves the greatest level of protection. So rather than limiting this to a narrow category of medical choices, with respect, I think it should be expanded to a broader category of medical choices and medical privacy to include whether you have an artificial hip or an artificial valve. And certainly through the genius of medical science, there'll be more and more options available to improve and enhance health. Certainly through a greater awareness of CAM, complementary and alternative medicine, there's more and more awareness of things we can now do to have a healthy immune system through a healthy diet and healthy lifestyles. But all of these are intimate and personal choices, whether we go the traditional science allopath route or the more broad complementary route. These are the types of choices where the individual must have the liberty to choose and the privacy to protect and not be bullied by either the private sector or the government sector.
Representative Lepore-Hagan.
Thank you, Mr. Chairman. Through the chair to the witness, thank you for being here today. I don't know if my microphone is on. I'm just going to go back a year and a half and just talk about an article I read before the quarantine and before the global pandemic, and it was in the New York Times, and it was describing or explaining what a global pandemic was, because it had been 100 years since we've had a global pandemic. And at the beginning of this whole trauma that we've all gone through globally over the past year and a half, one of the things that kept resurfacing was, well, how are we going to fight this? And everyone was looking for the save-all. How will we get out of this? And the vaccination was the common thread that everybody went back to. So if we don't trust science, if we don't trust our medical professionals, we will be back in potentially a resurgence situation. How do you propose that we fight it if we don't fight it with a vaccination?
Through the chairman, thank you very much for your question. That's very good. And it gives me the opportunity to illustrate another important, hopefully, takeaway from all this, that the first obligation of every citizen, and of every society for that matter, is the health of its people. Vaccines come after health has failed. And so are things that, rather than looking to a vaccine as a panacea to fix and cure everything, the public policy should always focus on the health of the individuals and encourage through diet, education, nutrition, healthy living, not getting sick in the first place. The global pandemics every year. I mean, the flu is a pandemic. The flu is a pandemic. The common cold is a pandemic, not a very serious one. But 1918 was a very serious year for the flu. Hospitals were stressed. There were tents, out in the streets at the Cleveland Clinic to deal with the flu. So this is not, this is worse than some, but there are pandemics all the time, and there absolutely will be other pandemics in the future. So it's certainly an appropriate question, but one of the takeaways here is going to be, at least from the federal government, we're now seeing the initial signs of this, over-reliance on vaccine and under-reliance on repurposing traditional medicines, such as ivermectin and hydroxychloroquine, There are doctors now, prominent doctors, saying that this is largely a serious disease because of vitamin D deficiency. And so I think we need to keep a focus on those things too. And an excess focus on vaccine undermines the focus on healthy living and alternative choices that doctors can provide besides just waiting around for the vaccine. And so, yes, we need to be prepared. The world was clearly not prepared for this pandemic, nor is the world prepared to do the national security things we need to do with, frankly, with our military adversaries to keep us safe. So we need to make some adjustments there as well. But there will be more pandemics. We definitely need to be prepared at the federal, state, and local level. We probably need much better contact tracing, for example, and that's a local requirement, so that cases that do break out can be addressed. But the emphasis should be first on health promotion rather than, let the body do the lion's share of protecting individuals. Without our body's immune system, we'd be gray goo in 2 or 3 days. So that's where it has to be first. And an excess reliance and dependence on science to fix everything risks too much to your health.
Committee, additional questions? Representative Stewart.
Thank you, Mr. Chairman. Thank you for your testimony, sir. Just wanted to follow up on one of your points in your testimony. You testified about Florida. It's my understanding, reading some of those articles, that when Florida passed its recent vaccination passport ban, it actually exempted the healthcare industry. Is that your understanding as well?
Thank you for your question. And through the chairman, I'd have to check the legislation. I don't think there's an exemption, but the vaccine passport is a somewhat different approach, than it would be illegal under this law here in Ohio. I'd have to check that, but the healthcare industry already has the protection to employees from the Title VII requirements going back to 2007. And they have a different set of concerns, obviously, because there's a more concentrated concern for disease in that industry, but I honestly don't know without checking the legislation.
Follow up, Mr. Chairman. Just for the record, I'm reading from the Orlando Sentinel in May of this year. Recent legislation signed by Governor DeSantis excludes the healthcare industry from his vaccination passport ban, exempts hospitals, nursing homes, assisted living facilities, et cetera. Follow-up question is that, we have certain standards in private business all the time for employees. You have to be able to lift some odd pounds. When I was in the military, I had to be able to run the 2-mile run in certain odd time. I think I got half a dozen vaccinations in one day as a requirement to be an infantry soldier. If we're looking at the healthcare industry, is it your testimony that it is unconstitutional for a private hospital to require an intensive care nurse to be vaccinated against the measles?
Thank you for your question, and through the chairman. Is it yes. And the short answer is yes. Can they have that as a suggestion, encouragement? Can they require accommodations? Certainly, absolutely. But bodily autonomy, as it's currently understood in our case law, is that it's a boundary you cannot cross. We've heard the refrain. It's sometimes translated in the popular parlance as "my body, my choice." And so I think hospitals in the healthcare setting have all kinds of ways to reduce risk to patients and should reduce risk to patients. But there are other ways of achieving that absolutely laudable goal than through requiring a person to sacrifice and alter their immune system. So I think the goal can be achieved in an appropriate, scientifically evidence-based, rigorous way without requiring a vaccine.
Committee, additional questions? I have one final question. It's more of I'm learning process I'm going through with you, Mr. Moody. Near the end of your testimony, you mentioned that vaccines are the only products sold in Ohio for which the federal government has banned access to traditional common law tort system. 2 paragraphs later, you state, rather than simply protecting Ohioans against public and private mandates, the legislature might well consider banning products that are exempt from tort liability. In your opinion, It's just your opinion, the expertise you've provided. How would Ohio's business community react to that, since there's been suggestions that they're negative to this bill as it currently stands?
Thank you, Mr. Chairman. Well, the tort system provides a second or a first line of protection along with the regulators in ensuring safe products. It's really a cooperative effort. One of the reasons for the Vaccine Act in '86 was the tort system had largely failed because it was too expensive to hire lawyers and sue Big Pharma. One of the reasons they got immunity is because they sort of conned the Congress, said we're going to stop making vaccines unless you give us this legal protection. Congress certainly could have provided an insurance system like flood insurance or the like to deal with that while protecting tort remedies. So tort, I don't need to speak for the trial lawyers, they'll certainly speak for themselves, but they are strong advocates to ensure safe and effective products and services, and it would be a benefit if that were available. The business community, maybe it could be fair to say, loves immunity from lawsuits. Shakespeare said, let's kill all the lawyers. So it might be that the business community would prefer broader immunity. Some states are considering various kinds of employer immunity just for COVID when they return to work over the work-related amelioration measures. Can you be sued as an employer if you don't have enough ultraviolet lights and the like? So this is a very difficult question people are just beginning to work through. But the blanket immunity given to the vaccine makers, in my view, goes way, way too far, especially when you're looking at accomplishing the socially desirable goal of high vaccine uptake, health of the population, yet reasonable access to sue. Right now, children, certainly for the COVID vaccines, there's no access to compensation. It's yo-yo, you're on your own. For children, even though the federal program has paid over $4 billion and 4,000 claims, it's really largely ineffective. The injury reporting rate, we heard this last week, is only about 1%. And I can tell you as a lawyer in vaccine court, it's a miserable, horrid place that's vicious and ugly, and we can't even get access to the basic scientific data. That's access to the health of the control group, the unvaccinated control group, to be able to win these cases. So when we have a developmentally injured child, autism for example, and the typical award for autism in that court's been $5 to $20 million, but yet they'll still tell you publicly, we've never compensated an autism case. It's just a lie. So it's a miserable, horrid place from the point of view of ensuring compensation that Congress intended. Congress said, look, we're asking these kids ethically to take one for the team, we better take care of them, and that's woefully inadequate. We don't even know what the true rate of injury is because that data is kept, as I said, more secret than our nuclear codes. So I think in general, tort immunity is dangerous because it takes away one of the important protections along with regulation, but there are probably limited situations where some tort reform and some limitations are appropriate.
Thank you. Dr. Liston.
Thank you, Chairman. Thank you for your testimony. I recognize that your background is law and not sort of medicine and science, so I wasn't going to ask this, but then you talked a little bit at the end about other treatments, and so I just want to understand sort of the mindset that you're coming from, because we're talking about the vaccine, and you had indicated that you thought it was, unstudied and unsafe, and so that was a component of the testimony. And in that mindset, I mean, we have had 300 million doses in the U.S. It went through phase 1, phase 2, phase 3 trials with impressive outcomes in terms of infection prevention. And then you're comparing it to ivermectin and said that ivermectin, which is an unstudied drug that in terms of treatment or anything related to COVID without actual FDA approval for this, and saying, well, we shouldn't use this vaccine, but we should be using ivermectin. And so I guess that to me, it's a little bit of cognitive dissonance. And so I guess I'm trying to understand where that conclusion comes from.
Well, through the chairman, Dr. Liston, thank you very much. First of all, I'm not saying, never have said we shouldn't use a vaccine. I'm saying it's a matter of choice and liberty. And as a matter of law and fundamental constitutional law, that right to choice should be absolutely protected, and that's the right to choose to take it or not to take it. On the science, it's really the FDA has said that the risk of a potentially dangerous disease, COVID, justifies the lack of information. They haven't even given the COVID vaccines final regulatory approval. So the science is, shall we say, not settled as to even the safety of the vaccines. It has limited approval for ivermectin, hydroxychloroquine, and countless other repurposed drugs. They have been approved as to safety for 50 years or more. There's over 200 studies on ivermectin, I think over 50 on hydroxychloroquine. And they're, as is usual with science, there are some that say it's appropriate in limited circumstances, and some say, like for ivermectin, if you take it too late, it won't do anything. So science is a process. It's not a destination. It's a process of testing and retesting and repeating to test hypotheses for patient groups, for disease conditions, et cetera, et cetera, et cetera. When someone says there's a consensus in science, I get really scared because, last time there was a consensus was the earth was flat and Galileo was excommunicated. And then that poor hand-washing guy, Semelius, was kicked out of the profession because he said that doctors ought to wash their hands before they examine pregnant women. So consensus is a dangerous word because science is a process. The World Health Organization, I think, has finally said ivermectin does reduce the death and mortality if it's used in the very, very early stages of exposure or as a prophylaxis. The point is, science will, as a process, sort these things out. Ignorance will not. Censorship will not. So that's the problem I have. The problem as a lawyer, I want to protect choice. Sometimes patients will make poor choices. That's why they have doctors to advise them. But if a doctor says, I think you should take ivermectin as a prophylaxis, I'm a trained professional and it's based on my judgment, based on these studies, they should be able to get a prescription for that from their state pharmacy without being bullied or threatened, and certainly without the doctor's license being threatened. Because in medicine, I don't need to tell you, you have the license. It's an individual profession. Your ethical duty is exclusively to your patient. First, do no harm. But those are choices for doctors and patients, and not choices for governments. They can certainly advise, they can certainly fund the science, but to cancel the science, to censor the spokesman, to kick people off of YouTube who are providing reasoned alternatives is the wrong way to go. So I can't say for sure you should take the vaccine or not. I can say for sure it is not an FDA-approved product at this point, and may never be because it's found to be unsafe or too risky. But I can certainly also say that certainly as to other FDA-approved products or even over-the-counter drugs or over-the-counter supplements like vitamin D, a patient in consultation with an appropriate medical professional should have the absolute right to take those in pursuit of their own health.
Representative Young.
From the chair to the witness, thank you for being here today. I have a question. Since you mentioned that this was in relationship to businesses and the impact to them, if the list of companies and organizations that we received and that was shown in some of the questioning earlier, would those organizations being opposed to this legislation, could this backfire on them, and how would that take place in litigation, in your perspective?
Thank you for your question, and through the chair. It's unsettled at this point as to whether a no jab, no job rule for employers will trigger workers' comp liability. There's a Maryland case from about 20 years ago where it did. So that's uncertain. Certainly you could amend your workers' compensation law to prevent that from happening. But it's uncertain. But there's sort of two categories, as employers and customers. To the extent that there are requirements put on employees, there's certainly going to be, and someone's fired, there's certainly going to be wrongful termination litigation. There's certainly going to be litigation over implied contracts. This will be added to their employee handbook since obviously it's a new disease that they're treating. It gets them into an area literally of practicing medicine. Their employee handbooks now are going to have not only your vacation schedule and your benefits, but it's going to also have all the things you can and can't do on your lifestyle. And because there's just no end to this slippery slope once employers make health decisions for their customers and for their employees. Privacy is a huge problem. Are they going to have to see the private medical records? Are they going to have access to the vaccine information system, for example? Employers, do they really have the time to do complex health screening, or do they just rely on employees to take care of their own health? There's just no end to this. And so a backfire, you asked the question about backfire, it's a slow problem. It's like the frog in the pot of boiling water. I mean, a state with lots and lots of fuzzy business regulation is going to be known over time as an unfriendly business environment, just as a state with very high corporate taxes. So it won't happen all immediately, but are businesses attracted to low tax jurisdictions? Absolutely. Are businesses attracted to low regulation states? Absolutely. So it's not going to happen if employers do this, and do it on a rampant basis. I mean, look, Professor Soule at Stanford famously said, "Oh, we don't need laws about discrimination against African Americans because companies that do that will suck and they'll go out of business." He's absolutely right. Woolworths, if they weren't serving African Americans, their lunch counters down south, eventually they'd go out of business because they're not going to get as much business. And that would happen here. If employers don't serve employees or don't serve customers that aren't vaccinated, eventually the marketplace will correct that. But in the area of other civil rights, we didn't wait. We said this civil right is too important to leave exclusively to what they called in the Lochner era laissez-faire capitalism. And that's just a choice in balancing civil rights against business rights that we decided some civil rights are so important we're going to pass laws to protect them. So yes, there may be a backlash, but I think this is such an important civil right, it should be implemented in law at this point.
I have a follow-up. Thank you, Mr. Chairman. Through the chair to the witness. Is there another time in history where there's been so much fear-mongering and misunderstanding, confused reporting, data not accurate throughout the country? Has there ever been a time in history where these types of extremes in the workplace have occurred, to your knowledge, in case law?
Thank you for your question, and through the chair. No, in fact, if you go look at the other major pandemics, 1918, 1957, they didn't hit the national radar like this one does. This is a little worse. Certainly, the original concern coming out of the Ferguson model, on March 6th last year, when we said we could lose 3.2 million Americans, there was an initial terror that hit, certainly to flatten the curve. We possibly early on overcorrected, but with frankly the best of intentions, because we don't want to get into a triage situation where we're leaving people in the streets. But as things have gone along and we've learned about the differential impact of the disease, it's primarily older people with comorbidities, I think it's fair to say, and Justice Gorsuch recognized this in his decision in opening the churches in New York, in his concurrence, he basically said, look, this was a super scary emergency at the beginning, and now we're beginning to get it under control and understand it more and can target the interventions more appropriately to those who are most vulnerable. So I think there has been a learning curve. But I think partly because of modern media, partly because of the politicization of almost everything in our culture, this has gotten more attention. And it's, in the pantheon of pandemics, probably certainly worse than the seasonal flu, worse than the traditionally circulating flu. Probably it's just right up there on the same order as the 1918 flu, but that affected young people as opposed to the very, very old, so there's a little bit of a differential impact. So this is one of the worst, and it's magnified probably just because of the impact of easier communication and the fact at this point in our culture virtually everything is being politicized, including science.
Thank you. Thank you, Mr. Chairman.
Ranking Member Russo.
Thank you, Chair. Thank you to the witness for being so patient with our questions. I know we've kept you up here for a long time. But I did just want to follow up on something that you said. You mentioned the slippery slope, and you named, several considerations. But I would just like to point out that many of the considerations that you brought forward on this slippery slope are already protected under the American with Disabilities Act and under the Civil Rights Act of 1964. So again, I go back to that EEOC position paper, and granted, they could continue to add more clarification in many different areas. But, there are already legally, both at the federal level and at the state level, accommodations that must be made for employees. And as you noted previously in your statement, you are not aware of any existing lawsuits or complaints for someone who has been fired for not taking the COVID-19 vaccine. So again, what is it that I guess on that slippery slope that you mentioned is not already covered under the American with Disabilities Act and under the Civil Rights Act of 1964?
Through the chairman, thank you for your question, Member Russo. I think, yes, there is a lawsuit out in New Mexico, so there's at least one that I'm following. Part of it is because I think as long as these are still experimental, in the EEOC's commentary, I think was focused on a time when they would achieve full licensure. But it is absolutely clear, the experimental, because of the federal preemption, that the experimental vaccines will never become mandates once it gets litigated through the courts, just because we can't, under federal law, require people to be guinea pigs. So, yes, there is a complex set of protections built into the ADA, to the federal civil rights laws and things like that. So to some extent, what we're talking about with this bill is kind of addresses a lacuna in the protection for civil rights. And it's certainly in response to some of the concerns over COVID, but there are a growing reliance, let's say, on shifting governmental choices to the private sector, in part because many governments at the federal and state level are frankly crippled from making a difficult choice. And so these choices get transferred to the private sector. And yes, this is maybe the first major time when we're asking barbershops and hair salons and pizza parlors to behave like doctors, and study the guidance and study the journals and listen to Dr. Fauci rather than, looking at their quarterly reports. But if this takes hold and there is a widespread use of asking businesses to practice medicine, then it won't be very much longer when businesses are asking you, things like, do you have a gun at home? Are you smoking at home? Are you exposing your children to smoke? Because it's at the moment in our culture, it's very tempting to transfer government decisions to the private sector, in part because we're used to the idea that constitutional rights apply only against government. Thus, Facebook can censor as much as it likes. A hair salon can decide who can work there, if they're vaccinated or not, or wear a mask or not. So it's tempting, and that's one of the reasons we have statutes to protect civil rights, is because the Constitution doesn't fill that gap when private companies start engaging in traditional government functions. It's called the police power, the regulation of health, safety, and morals. But I think it's an area we don't want to invite the private sector into, and that's why we have this category of law called civil rights in the first place. And that's why we have minimum wage and maximum hour laws and child work laws and things like that. We've already, regulated private business, small business, big business quite extensively, because we realize that pure unrestrained capitalism, much as I love it, being a libertarian, does have limits, that society has to have a system of ordered liberty or a class of rights that simply can't be infringed by government or citizens. We have constitutional rights that protect you against government. We have statutory rights, the civil rights that protect you against undue coercion from private business.
Thank you, Mr. Chair. Just one quick follow-up. Again, just reminding the committee that there is nothing right now that is requiring any business to have a vaccine requirement. There is no state vaccine passport program, nor nothing requiring businesses to offer incentives to their employees or customers for having the vaccine. So that is not the case. There are no requirements by the state to do that.
I agree, no requirements by the state perhaps, but there are businesses discriminating by having some employees vaccinated go to the left, employees not vaccinated go to the right. So if you're saying discrimination isn't occurring, I would have to take a question with that. Mr. Moody, if businesses can mandate that you take, if we don't pass this law and businesses mandate that you have to take a for-profit pharmaceutical product As you just had the discussion with Ranking Member Russo, where do they stop? Can they tell us no smoking in our lives? You can't get in a swimming pool, you might drown. You're a valued employee. We have to have you back. Can they tell us to take our vitamin D every day? Where does this end?
Mr. Chairman, thank you for the question. That's a concern, is the slippery slope, that if because of this cultural tendency to shift government choices to the private sector, government decisions that can be made by government can ban smoking because it's a dangerous product. We haven't done that. But do we really want private businesses now to start banning smoking at home or gun ownership at home, or carefully regulate the mental health of your children? Or could a private business say, for example, we're not going to hire you unless you agree to send your kids to public school? Because there's some hostility to homeschooling, there's some hostility to the non-public school system. And do we really want pressure brought to bear, even sometimes very subtle pressure, brought to bear on private businesses to engage in the category of regulations, police power regulations, that are traditionally those of government? And it's terrifying, frankly, that we're starting with medical choices, that private companies are going to make medical choices about how you alter your immune system. Suppose you say, no, I don't want the vaccine, but I will, as an alternative, we'll call it an accommodation, take vitamin D. Does that mean you bring in your records? Do they have access to, in order to enforce this, do they have electronic access to your private patient records? It's so, the desire to do good through the judicious use of expertise is such a powerful, lustful desire that protecting liberty against the desire to be ruled by experts is an overwhelming problem. So as experts get used to the idea that we can transfer government regulation to the private sector, it'll be very, very tempting to extend that to other areas besides just the instance of COVID vaccines and masks.
Mr. Moody, thank you very much for being with us today. We appreciate your testimony.
Thank you very much, Mr. Chairman and members of the committee. I'm available for other questions via my email and phone, and I appreciate the opportunity to come. Thank you so much.
Committee, thank you. We started strong, lots of questions from an expert that visited us from Washington, D.C. Obviously, we will not be permitted to spend that kind of time with every witness. I just felt like we would start it off strong and let everybody air out a little bit of their concerns. So thank you.